So you're leaving too?
Just going to.
No, that's fine. I'm out. I am not going to just sit here.
I'll be on the lookout for him.
No, I don't want to tell him. If you see him, tell him I don't want to talk to them at all.
All right. All right. But you still want to talk to me though, right? Questionable.
Maybe. How are you?
They got okay, and you?
I'm fine because I don't have anything to do. So, but we don't have a prosecutor, but.
We don't?
Yeah, well, they went somewhere.
All those having business people in the quick around here, yeah, to day subject sense of being back.
Maybe soon. I don't have anybody from the PD yet.
He's here.
Miss Feltus.
Good morning, Your Honor.
Hi.
Monty Feltus for the people. Your Honor, at this time, the people would waive any conflict between this honorable court and the Office of the Public Defender. The people do not believe that any conflict exists. We do make the waiver for the avoidance of all doubt.
Thank you, and welcome back.
Thank you.
Good morning, Your Honor. Laura Yagi, Assistant Public Defender. I don't know that I've ever done this, but on behalf of my office,
With that.
I'm just not prepared. But on behalf of my office, we likewise do not believe any such conflict exists. But in the avoidance of all doubt, we would waive if it does.
Court, for its part, also does not believe there's a conflict either. Any court rules or the cases decided thereunder to the extent a conflict does exist, given the waivers the court will sent to hear the matters. Court does call the case People State of Michigan versus Andrew Towler or Toller.
Feltus for the people.
David I. Goldstein appearing on behalf of the defendant. Get to the podium, state your name, please.
Andrew Jacob Tolder.
Waiving.
Yes, there should be a written waiver in the file.
Sir, you're waiving your right to a preliminary examination.
Yes, Your Honor.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, Your Honor.
You understand you will not have that hearing. You'll proceed to circuit court for further resolution.
Yes, Your Honor.
People also waive their right.
We do, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on count one with 2 vowels.
Your Honor, my client and I acknowledge receipt of a copy of the information. We waive its further reading. My client stands mute, asked that a not guilty plea be entered.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial in this matter set.
June 2nd at 1:30 with Judge Conklin.
June 2nd, 2026, 1:30.
Thank you, Your Honor. Okay, so
Okay.
Before we dive in, just a quick note. This commentary is created for educational purposes, designed to help those who may be confused or curious about courtroom processes. If you don't find it helpful, feel free to skip ahead. But for those who want a deeper understanding, stay tuned. It's about to get intense. What starts as a routine courtroom session quickly spirals into something far more unpredictable. We've got missing prosecutors, frustrated participants, and a judge trying to hold it all together while tension quietly builds. But here's the twist. Some of the most important legal decisions in this case happen during these seemingly chaotic moments. Pay close attention, because what unfolds here reveals how the justice system adapts under pressure.
Keep on going. Keep on going. What's you?
I don't know, but this is file.
What? I was just asking a question. We're up to something because you took offense at me, like pointing you out. Keep an eye on you.
May I approach to sign that information, Your Honor?
Sure.
wait, bound over. You
You're bound over. Yeah. I can't do it. All right. We're just on the case People versus Matthew Gale. Oh, this is what he's up to.
I was preparing for
What?
the upcoming jokes, but
What upcoming joke?
John Emery, Assistant Prosecuting Attorney, UK.
Good morning.
and Your Honor, 6'3" Joe Simon on behalf of Gail. And anyways,
Client's like 8 feet.
go ahead, Matthew Gale.
It is cute though. Okay, man, never mind, go ahead.
I'm scheduled for preliminary activities matter, Your Honor, and going around with, felony count made that if you're admitted, it's your court on issue, misdemeanor count.
Move to dismiss the felony counts, Your Honor.
So 1 through 3.
Yes, Your Honor.
Counts 1 through 3, 1, 2, and 3 are dismissed. I'll continue the defendant's not guilty plea as to count 4. Set a pretrial in this matter for
April 23rd at 10:30.
April 23rd, 2026, 1:30? 10:30.
I think I'm only saying this because this happened to me just yesterday. I think he does these at 1:00 now. Judge Fresh Hour. I'm okay, 10:30.
Hang on a second. Thank you for pointing that out, Mr. Simon.
Thank you, Your Honor.
What do we have? Hang on, we'll check for you. Just for you.
1 p.m. It's a conspiracy.
We're involved in one yesterday.
I learned that because they were. Thank you, Your Honor. Well, they were wondering why things kept getting set on the DV docket different than that time because I had one this week that was errantly set. So that's the only reason I mentioned it. But thank you, Your Honor.
That's what they give us.
I know it was their old time and they've kind of like quietly changed it and not really told everybody. So
Yep, nothing like communication. All right. Thank you, Bob.
thank you, Your Honor. What?
Well, everybody's leaving. Is that it for Joe?
That is.
Really?
Before.
Karen, I have a question.
Because there's nobody on that side.
Miss Doctor's clients in custody, she to go.
Well, look, why are you talking to me? I have nobody here.
Anybody here? Here.
Wow. That was rude.
Right here is a critical legal moment that often gets overlooked. When the defendant waives their right to a preliminary examination, they're essentially giving up the chance to challenge whether the prosecution has enough evidence to proceed. That's a big move. It speeds things up, but it also removes an early opportunity to poke holes in the case. Now, think about this. Would you waive that right if you were in this situation? Or would you want to see exactly what evidence the prosecution has before moving forward? Let me know in the comments.
So, where's everybody that would be over here? Where'd Yagi go?
Lock up, I think, Your Honor.
You know what? That's where I'm going to put Ann in a minute. Okay, so she went to lockup. I know. I was listening to you. Okay, I wasn't, but now I know. And so what happened to Warren Green?
Don't have that his client. So. Oh.
Who's on the other side? Okay, then I know who wins. No, I didn't say.
Those are the only other calls for attorney we haven't seen. We haven't seen Mr. Denowith or Miss Akira Akinroli or Miss Russell. Those are all at
Slesso, Akinroli, and Denowa.
or some of these resign, but they let us know.
So I should probably start yelling and get real angry, and then people show up.
So she works around.
What? It does. It does. Or just send Alan. No. Okay. So there are 2 public defenders.
That we've seen in 2 different cases.
And I'm going to step out briefly and I will be back.
That's okay. We'll talk about your lawyer.
Okay.
All right. So now everybody leaves. Beltis is gone. Anna left. I'm going to shock the world. I'm just going to start calling cases.
Do you want to?
I'm just going to start calling cases and just do I'm going to do what I want to do. I think that people will like it. Some of them. It's a good thing I'm so patient. That's my middle name. This is where I get in trouble when I don't have anything to do and there's no telling what I'll say. So what's going on next door?
Oh,
Yeah. Go ahead and look. See what's going on. If everybody's over there, then I'm going to do something to make everybody run over. Oh, there's Miss Sussel. Morning. Sussel. How are you?
They got okay, and you?
I'm fine because I don't have anything to do. So, but we don't have a prosecutor, but
We don't.
yeah, well, they went somewhere. We had no attorneys till you walked in.
Yeah, so. Thanks.
You know what we're doing?
I don't. Don't know.
So you're leaving too?
Just going to.
No, that's fine. I'm out.
I'm
I am not going to just sit here.
I'll be on the lookout for him.
No, I don't want to tell him. If you see him, tell him I don't want to talk to them at all.
All right. All right. But you still want to talk to me though, right? Questionable.
Maybe. All right. Or it's going to stand in recess.
All right. Good to see you.
Sorry.
2026. And be for me.
Thank you so much, Your Honor.
Thank you, Aaron. Court calls case People versus Calvin Cannon.
Good morning, Your Honor. Raise your hand on, please.
Good morning, Your Honor. Deborah Schlossel on behalf of the defendant, Kelvin Cannon. State your name.
Calvin Cannon.
Thank you.
Ma'am,
Ma'am, you don't have to take the baby out. That is fine. That is fine. I don't understand Sussel, but okay. What are we doing?
Your Honor, this is the case being transferred to preliminary examination of this matter. So unable to proceed on count one without further subject from count two with the evidence.
Your Honor, at this time, we would ask this matter be dismissed without prejudice since the exam was set for today and the witness has not shown up.
I will dismiss as to count one. Count two, I'll continue to defendant's not guilty plea. I'll set that for pretrial.
May 4th at 9
May 4th, 2026, 9 a.m. That's before Judge Washington.
Your Honor, that is a bad morning for me. Is there any way this could be another date, please?
No. Well, can be another date, but
I have to
talk
ask
to Judge
her.
Washington.
Okay.
Don't worry about that.
All right.
I only have one date. I do have an in custody date. What's my in custody?
It's April 20th at 9 a.m.
Oh, that's a good day for me. Thank you.
Of course it would be. What was that, April 20th at 9? All right, I'll set it for April 20th, 2029
Your Honor.
for Judge Washington.
Thank you.
You're welcome. Court calls the case, People versus Donovan Jankowski.
Motion to call this for the people?
And good morning, Your Honor. Lori Yagi, Assistant Public Defender, with and on behalf of Mr. Donovan Jankowski. It's approaching. Did you say your name for the court?
Donovan Jankowski. All right, I have before me a form that indicates that the defendant will be pleading to an added count for false pretenses under $200. That's a 93-day offense. Upon a successful plea to that charge, counts 1, 2, and 3 would be dismissed. Defendant is agreeing to 24 months probation. That's court's full understanding of it.
That is correct. The recitation, Your Honor.
Yes, Your Honor. Thank you.
May I have him sworn?
Raise your right hand. You solemnly swear affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the true self you got. Thank you, please.
Donovan Isaac Jankowski. Sir, it is this court's understanding that you're going to be pleading charge of false pretenses under $200. That's a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that, sir? Yes, sir. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour at 14A3 District Court. Yes, sir. You wish to plead guilty? Yes, sir. And to that charge, how do you plead? Guilty. Now, you understand that by pleading guilty, you'll not have a trial of any kind? Yes, sir. Signed an advice of rights form, is that correct? Yes. Any questions regarding any of those rights? No, sir. Please look at paragraph 5 on that form. You'll see a copy. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that. Yes, sir. You understand you're giving up your right to appeal of right? Yes. You on probation or parole? No. Is it promise other than what's been stated here today to get you to plead? No. Anybody threaten you or court? No. Doing this voluntarily? Yes. Of your own free will? Sir. And also because you believe that you're indeed guilty of this offense? Yes. Date of June 23rd, 2025. Location of South Main Street near Commerce Park Drive in the city of Chelsea, Washtenaw County, state of Michigan. What do you do makes you think that you're guilty?
I passed off a counterfeit bill.
All right. And that was at some business?
Yes.
All right. And so you passed a counterfeit bill to get goods or services?
Yes, I paid for some groceries with a counterfeit bill.
Okay. Sir, I do have to advise you that if you commit misconduct as defined under the Michigan court rules between the time of my acceptance of your plea and your time of your sentencing, that you would not be entitled to withdraw your plea and the court would no longer be bound by any sentence evaluation or recommendation. You understand that?
Yes.
All right. Counsel, are you aware of any of the promises, threats, or other inducements which have led to this?
No, Your Honor.
No, Your Honor.
Have I complied with the court?
Of course, that's fine.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 4. Counts 1, 2, and 3 are dismissed. Pre-sentence investigation and report is ordered at 14A3 probation. Sentencing in this matter will be
At 9 a.m.
May 18, 2026, 9 a.m. before Judge Freshour. And we'll continue.
Thank you, Your Honor.
Oh, well, listen, I'm not.
Court does call the case of the People versus Abdul Latif.
Assistant Public Defender, on behalf of Mr. Abdul Latif, who stands to my right. Sir, would you please state your name for the record?
Aziz Latif.
Your Honor, this morning, for prelim, excuse me, I am unable to receive.
Defense moves to dismiss.
People being unable to proceed, this case is dismissed. That's without prejudice on the motion.
Thank you.
Thanks, John. I'll try to call you.
Why did you change the order?
I get you.
Court calls the case. People versus Rayshawn Ellis.
Ashley Feltus for the people.
Assistant Public Defender, Chinaki acting ruler, Your Honor, on behalf of Mr. Rayshawn Ellis, who's approaching. Rayshawn, state your name for the.
How come she went next to first? Did not come over to see me.
I saw
Her around trying to figure out where she was.
Ann, Judge.
And then all of a sudden shows up here. Like, you know what I mean? Yeah. Now probably wants a favor or something. Nope.
It's so good to see you.
Yes. As it is you, finally.
Thank you. Rayshawn, state your name for the record, please.
Rayshawn Ellis.
Thank you. All right, what are we doing?
It's better that people are unable to see.
We do move for a dismissal, Your Honor.
If it weren't for him, I so much don't want to grant. People being unable to proceed. This case is dismissed on defendant. Thank you.
He said.
You're welcome. Court calls case People versus Defiant Morgan.
Ashley Feltus for the people.
Good morning, Your Honor. Justin Zade appearing on behalf of Ms. Morgan, present stand to my right.
Defiant Morgan.
Thank you.
Your we just this morning for a preliminary examination, the people would have been able to proceed to examination. Conversations this morning, he's hoping we may be able to reach a resolution and we're ready to get there this morning. We are respectfully requesting our time to have that conversation before we allow.
That's an accurate recitation of where we stand as of now, Your Honor. We share that request.
Two. That
I know.
I don't do that. How much time did you need?
We get about 4 to 5 weeks, Your Honor. I
have the 28th and May 19th.
don't know that the 28th will be announced.
May 19th works for us, Your Honor.
Preliminary examination will be adjourned May 19th, 2026. 9 a.m. before me.
Thank you, Your Honor.
Thank you very much, Your Honor.
On continue. Thank you. You know, it's foul test. She talked me into 2. Are we ready? This one.
Yes, sir.
Court calls the case People versus Jerome Adams.
Morning, Your Honor.
Thank you, Your Honor. Alex Warren Green on behalf of Mr. Adams.
My last one.
Yeah, it's for this one.
State your name, Jerome.
Oh, Jerome Adams.
That's line right.
Your Honor, this is the day and time for a preliminary examination. Everyone understanding is going to be a waiver. There's a few things for the record. That waiver is with the understanding that we'll not add a larceny in buildings, as well as 2 additional strangulation or assault, but intent to do great bodily harm. In this case, we also will dismiss the half 4 that's on this case. Currently, we're going to continue negotiating on the matter.
Your Honor, my client has signed a waiver form. I do believe he wishes to waive his right to an exam. With respect to the 4th notice, I'm not sure that one was filed, but the people indicated they would not add.
Sir, waiving your right to a preliminary examination.
Yes, Your Honor.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Correct.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, Your Honor.
People also waive the right. Preliminary examination having been waived, defendants bound over on count 1 with 2 following.
Your Honor, we acknowledge receipt of the information, waive its reading, and stand mute.
And in every way, form, or reading, standing mute to both charges, court will enter a not guilty plea. Pretrial will be set for
April 23rd at 1:30 with Judge Slay.
April 23rd, 2026, 1:30 before Judge Slay.
If I may bring up, something as, I guess, a bit of a warning to the defendant. We received information that his family members have contacted the victim of this case, asked her to put, money towards his bond of promissory. That is obviously, it's a violation. Recommend anybody to do that. It's fully inappropriate in general. So just as a warning, should not be.
Your Honor, I believe my client understands the provisions of the no contact order. I'll remind him moving forward, certainly not to have any contact directly or indirectly with the complaining witness in this matter.
You understand that, sir?
Oh, yes.
Pardon?
Yes, sir. Yes, Your Honor.
All right. So talk to your family members. You probably need to let them know that if that kind of behavior continues, you're the one that's going to pay the price for that.
I understand. I made that kid because she was calling, asking about some stuff that was left at her house.
Hold on. Don't
I told her not to.
know.
I'm sorry.
Yeah, I'm just saying,
Don't talk to her. No.
from your standpoint, you need to let your family.
I already told him. Don't talk to her.
All right.
I got
All right. Thank you. Bond will continue.
Thank you, Your Honor.
No way. Really? Guess if you wait, good things happen. Yes, you may. I needed to talk with you anyway. So I'll go and back. I need to talk with you anyway. Yeah. What? I know you said this. I wasn't there. 14A. Is that it for the day? The whole day? It's like letting a cattle dog loose. I'm going to destroy something.
It's gonna not work. So, that's interesting. These are so sad. You work with Sandra, right? Yeah. Oh, I used to work. Wasn't she that? Yeah, I don't. You can have me. Oh, I know.
All right. 14A District Court for County of Washington, State of Michigan, now in session. Although kind of business here, the Honorable Judge Day, subject Simpson preside.
Take a seat. And Mr. Cook.
Your Honor, Raymond Cook for the people. Your Honor, the people waive any potential conflict between this honorable court and the office of the public defender. While the people do not believe that any such conflict exists, we make this waiver in the avoidance of holdout.
Thank you, sir. Ms. Payne.
Public Defender Natalie Pate, on behalf of the Public Defender's Office, Your Honor, likewise, Your Honor, office does not believe a conflict exists between this honorable court and our office, but if one were to arise, we waive such.
Court for its part does not believe there's conflict either in Michigan court rules or the cases decided thereunder to the extent a conflict does exist given the waivers the court will consent to hear them. Were you able to talk to the individual? Which
Yeah, would you like? Yeah, she is not.
you wanted a breakout. I don't do that. And you tried to ask and like on into giving you a breakout room. Didn't you, Miss Payne?
I did. I didn't.
I walked in and I felt that there was some conspiracy going on in the building. I felt it from the door as I was coming down the hallway.
I did bring them into the conservatory.
So you admit it?
I admit that I brought them into the conspiracy, but no, I was very straightforward with conspiracy. So
you're just not very good at it.
correct.
Right, okay. Did you want a breakout room to speak to Mr. Wilson?
Listen, that would be amazing.
And no. No. Mr. Wilson?
Yes, sir.
What I'm going to do is I'm going to pass your matter. I was going to call your matter first. I'm going to pass your matter and let your public defender go out and have a breakout room with you and talk to you before we call your case. Okay, sir?
Yes, sir. Thank you.
Thank you.
Thank you so very much, Your Honor. I appreciate it.
I'm keeping track, you know.
That is fair.
Court does call the case. People versus Michael Clark.
Good afternoon, Your Honor, Raymond Cook.
You know, Then give me a sign.
I'm innocent, Judge. Joe Simon on behalf of Mr. Clark. State your name, Michael.
My name's Michael J. Clark II, Your Honor.
Your Honor, Mr. Cook and, pardon? No.
Okay.
Mr. Cook and Ms. Zenda are working on getting me some supplemental discovery. They've made requests to the police agency for some videos, and I think that if we adjourn the pretrial just one more time to the 20th, we should have it by then.
He picked a date. Set the date. Did you give it to him beforehand? April 20th, 2026. 1 p.m. Bond will continue. Thank you.
Thank you.
Thank you, sir.
You can be right outside.
Thank you, Your Honor.
Well, sir. Court does call the case, People versus Carmen Folks.
Good afternoon, Your Honor, Raymond Cook for the people.
Did you have something else, Mr. Thurman? Or?
No, Your Honor. We'll continue tomorrow morning. I know that one.
Oh, we're switching? Okay. Oh, we're switching.
I think it'll be over by half.
Good morning.
I'm a big pen guy, right? Just saying. Go ahead.
Good afternoon, Your Honor. Robin McCoy, P63057 on behalf of Ms. Carmen Folks, who stands to my right.
Your name, ma'am?
Carmen Renee Folks.
Thank you. All right. What are we doing?
We filed a motion to withdraw. There's been a breakdown, and so it signed the consent to release me. So,
is that all correct, ma'am?
Yes.
What are you going to do regarding counsel in this case?
I would request a public defender.
So I don't think the PD wasn't on this case.
I don't think so, because we were at the arraignment.
Got it.
So we were there.
All right. I will sign the order to withdraw. Ms. Folks, what I'm going to ask you to do is wait just a moment till Ms. Haight comes back so that they can make sure that they've got all your information and everything. And I'll call your case back up at there.
Okay.
Okay. All right. Thank you, Ms. McCoy.
Okay, it's good seeing you, Judge. And I did send you some information about some Van Zed events that are coming up. So.
Yes, you did. And I read them all. They've been booked.
Good. All the stuff.
Thank you, ma'am. Court calls the case, People versus, that was also a conspiracy. They're everywhere. Court does call the case, People versus Mahmoud Saleh.
Good afternoon, Your Honor, Raymond Cook for the people.
Thank you. Good afternoon, Your Honor. May it please this court, Amir Makdad representing Mr. Zali.
Said that it's Mr.
Counselor, I don't know if this is the attorney's phone.
Yeah, I'll give it to her. Thank you.
Sorry, Your Honor.
No, it's okay. All right. Now, no conspiracy, because Mr. Makdad is here.
I don't engage.
Everything is above board.
Oh, so no engagement in conspiracy theories here. None, zero.
All right. And what are we doing on this case?
Your Honor, respectfully requesting a final settlement conference.
Right. I'm assuming you don't want the April dates.
That would be correct, Your Honor.
I would like the April date if it's available, Judge, but I know the court's, it's a short turnaround. I get that. Unless there's another date in the near future.
Well, there would not be one. The way we select is every 2 months.
Right.
So my April dates are coming up, which would be the 10th and the 13th. But
Your Honor, given that
Mr. Cook looks panicked. Go ahead.
Given that Mrs. Ed isn't here and this is her case, certainly, obviously, we're all the same office. I'm just concerned about that witness turnaround. I don't know how quickly it would take to get that witness here. So I'd be requesting the June date.
What are my June dates?
It's June 5th.
The 5th is fine, Your Honor.
June?
Yeah, June.
Okay.
If it has to be in June, yes, unless it's a bit, we can't, it seems like we can't do April, Your Honor. That's, so I understand.
Yeah, right. And okay. Final settlement conference in this matter will be June Well, hold on a quick second. Mrs. Zender will not be back this Friday.
Correct. I'm covering on Friday as well.
June 5th, 2026 at 9 a.m. for jury final settlement conference. Jury selection, if necessary, will be June 8th, 2026 at 8:30. Both of those are in.
Thank you, Judge.
All right.
Have a great day, you and your staff. Thank you.
Thank you.
All right. Thank you. Court calls the case of the People versus Mackenzie Nyquist.
Good afternoon, Your Honor. Raymond Cook with you.
Good afternoon, Your Honor. Matthew Cow with University of Michigan Civil Criminal Litigation Clinic. Requests permission under MCR 8.120 to appear on behalf of Ms. Mackenzie Nyquist and under the supervision of Attorney Sarah Sallin.
Oh, I guess. Permission to practice is granted.
Thank you, Your Honor. And Ms. Nyquist is online. Mackenzie, if you could just turn on your camera and say your name for the record.
Mackenzie Nyquist.
Thank you. And good afternoon, Ms. Sallin.
Good afternoon, Judge.
All right. Okay, you know what? Hang on one second. I'm having an issue with my screen. There you go. All right. What are we doing? Don't everybody speak up at once.
I can speak, Your Honor. We have reviewed the PSI report created by the probation office with Ms. Nyquist and are in agreement with just a few comments.
All right. And there are no material deletions, corrections, or additions to that report?
None, Your Honor.
All right. What would you like to say before I do impose sentence?
So we would just request respectfully, Your Honor, that all waivable fines be waived. Ms. Nyquist is working on completing the ability to pay form and will do that shortly.
Ms. Nyquist, I need your camera back on, please. Thank you. All right, go ahead, Counsel.
I was just going to add that she is the sole income earner for her household and is currently working 2 jobs. So once she gets that form submitted, we would respectfully request that all waivable fines be waived.
Nyquist, anything you want to say before I do impose sentence?
Just one additional comment, Your Honor. With regards to the probation term, the probation office has informed Ms. Nyquist that she would be eligible for early termination pending the successful completion of her counseling course.
Your Honor, I believe that since this is a domestic violence case, it's not statutorily eligible for early release.
Your Honor, typically on a domestic violence case, that is not the case. However,
What is not the case?
that she can request an early discharge from probation should it be done. She has to come before this court to make that request. The probation did recommend the 2-year term, given that Ms. Nyquist does have priors.
And so, Counsel, I don't know if that changes your client's perspective in terms of this sentence or anything you want to argue regarding this sentence.
We would just ask that, given her efforts that she's demonstrated to try and better herself and taking her own initiative to take courses prior to the probation sentence, that she be considered for early termination pending the successful completion of that course.
Well, I guess typically for me, that's not necessarily how it's done. I mean, if somebody comes in before me and wishes early release, I'm looking at the whole thing. I'm not just looking at whether they've done a particular thing. So as long as your client understands that that's the way that I work, I will go ahead with sentencing. But if you want me to do something else, then you need to let me know now.
I believe she understands. We spoke with her prior to this and discussed the conditions of the probation.
All right. Very good. Okay. Why do they do this? That's the second time of one additional thing. And I think it is? I think it's that M in the background and the national championship game, and they just are like emboldened to do stuff today. That's what
It's a conspiracy, Judge.
That's right. Everything's a conspiracy. Is this
No conspiracy here.
All right. All right. So, and it's really hard for me to look at that, Em, although I'm rooting for them. You're
I
like
appreciate that.
that one there. There's like three. My whole screen is full of them. Are you? Oh, you are you a? Are you?
Yes.
That's why I don't like you. All right.
Would it affect my sentencing if I said I was a party too?
What'd you say?
Would it affect my sentencing if I said I was a Sparty too?
You're a Sparty? Okay.
Oh yeah, I was raised in East.
You don't understand. I'm a Maryland Terrapin. So the fact you're a Spartan, it just got worse.
That was all hypothetically.
Hypothetically. Okay, now it's all hypothetical. I get it. All right. Counsel, what else did you want to say?
Just the final thing, Your Honor, is that we understand that the probation check-ins may be done by phone given the distance. Ms. Nyquist lives out in Newport.
Okay. For us, I leave how she reports to probation and to their discretion. If it does become an issue and then has to get to me, then that's fine. But as to how she would need to report and the frequency and those kinds of things, I leave that to probation.
Certainly. Thank you.
Anything else, counsel? Where did you say you were from?
Chicago, Illinois.
That's the problem. All right. Because you guys had a bad time coming to the tournament. But anyway, I don't mean to do that. All right. Ms. Nyquist, is there anything else other than proclaiming to be a Spartan that you want to tell me before I impose sentence?
No, sir. My counsel did a great job of covering all of it.
Okay. Thank you. All right. To send to the court, I'll place you on 24 months probation. You're to pay $555 fines and costs, $720 probation oversight fees. I won't be waiving anything. I will consider it once we get the ability to pay for them in. I will just indicate that you'll be on a payment plan as arranged by probation at this time. There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete a domestic violence program as directed by probation. There is to be no contact with Lloyd King except for child exchanges and communication via text regarding minor children only. You understand that?
Yes, sir.
Is there a family court case pending at this point?
No.
Or no?
No, it's closed out. It's been finalized for years now. We've had the same child custody for 5-6 years now.
Okay. All right. Very good. Then I won't worry too much about that then. All right. Do not go to the home or employment of Lloyd King. You are not to assault, terrorize, frighten, intimidate, threaten, harass, molest, or stalk anyone. You are not to possess any weapons, firearms, ammunition, or anything fashioned to be a weapon. You are to report to probation as requested by probation. That could include home visits. You're to comply with any and all circuit court orders, if any. I'll set a review hearing that's to be held June 15, 2026, 1 p.m. I will order 93 days in jail. That is suspended. Right? Okay. Thank you, folks.
Thank you, Judge.
Thank you.
Mhm.
Thank you.
Court calls the case of the. Can I go ahead with this one?
You can't do
Marco Arizanskowski.
Teresa Claire on behalf of probation, Your Honor, Mr. Arizanskowski is court for review hearing. He is compliant with the terms of order. Court may waive his appearance. Probation recommending that conditions of probation continue with a final review hearing being set May 18, 2026 at 1.
Hearing no objection, so ordered. Just another. Okay. I'll do that and then I'll go back to the other two. This one. Court does call the case People versus Anatoly Zabriskie. Is another.
And Assistant Public Defender Natalie Tate for Mr. Zubritsky, whose appearance has been waived.
Teresa Claire on behalf of probation, Your Honor, Mr. Zubricki moved in for the court full review hearing via the fund all terms ordered by the court. Probation recommends that all conditions continue with the next review hearing being 29/2026 at 1 p.m.
No objection, so ordered. All right, I'm gonna call this one before court recalls the case, People versus Commonwealth Folks. Folks, come on up. State your name again, please.
Carmen Renee Folks.
All right. Ms. Pate, while you were out, talking with Mr. Wilson, the counsel, her previous counsel, Ms. McCoy, withdrew from this case. And so therefore, and Ms. Folks requested an attorney, and so this becomes a public case.
Absolutely. Thank you, Your Honor. Assistant Public Defender Natalie Tate with and on behalf of Ms. Folks. Your Honor, I would request an adjourned pre-trial date so that we can receive and review discovery from the prosecutor's office.
In a public defender case, I will adjourn this matter then to April 20th, 2026, 1 p.m. Okay, Ms. Folks? You're all set. Thank
you.
Thank you. We need to call you.
Court does recall the case, People versus Kyle Wilson.
Assistant Public Defender Natalie Tate with and on behalf of Mr. Wilson. Mr. Wilson, can you please state your name for the court?
Kyle Wilson.
Teresa Claire on behalf of probation, Your Honor, Mr. Wilson is before the court for a review hearing. Since Mr. Wilson has been sentenced, he has not done anything with the terms ordered by this court. He was remanded into custody in Oakland County on a felony BOP, which was out there prior to him being sentenced here. He was sentenced to 244 days in that matter. He now has an estimated release date of June 24th of 2026. At this time, given the length of time that he's been in jail, probation's asking that the court revoke the probation that was ordered in this case and sentence Mr. Wilson to 365 days in jail with credit for 121 days served to date and to serve the balance.
Thank you, Your Honor. I was able to speak with Mr. Wilson regarding this, and I was able to get information with him and confirm an ex-jail. Although he was sentenced on this case back in December 22nd, he did have an out-of-county.
This case is a perfect example of how unpredictable courtroom dynamics can be, from procedural waivers and dismissed charges to emotional exchanges and last-minute legal decisions. We saw how missing witnesses led to dismissals, how plea deals reshaped outcomes, and how probation violations can quickly escalate into serious jail time. At the end of the day, the judge balanced efficiency with fairness, ensuring each case moved forward despite the chaos. It's a reminder that the legal system isn't always smooth, but it's constantly adapting in real time. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
So he wasn't physically released from the jail until January 11th. So that being said, we do acknowledge he was out of custody and on probation from January 11th to at least February 25th, in which he did not complete that substance abuse assessment or the domestic violence program. Mr. Wilson does to me, I do not have documentation of this to provide, but he does state to me that he did enroll in the DV program and pay a $50 fee. However, he was not able to attend any classes due to him being remanded on the 25th of February to the Oakland County Jail. Your Honor, he's respectfully requesting if the court would consider sentencing him in this matter, not to the full year in jail, but if you would consider sentencing him to 200 days jail, credit for 121 days served. He's hopeful that at the end of June, which is his current estimated release date from the Oakland County Jail, he hopes he could be released from both matters around that time and be able to move on with his life and his matters. And he's deeply apologetic to the court and hopes to just put these matters behind him.
Mr. Wilson, anything you want to say?
While being incarcerated, Your Honor, I have completed classes and courses. I have certificates completing a domestic awareness course on the tablet, cognitive awareness course on the tablet, and also a substance abuse and anger management. I have certificates to prove and provide if necessary. I enrolled in the domestic abuse class, but I couldn't actually attend because I've been incarcerated, but I have been attending classes on the tablet to try to work out or help me with that abuse class, but not sure if that actually helped. I do have certificates for the completion of those that I've been doing in here, though.
All right. Okay. Thank you, sir. Here's what I'm going to do. I'm going to revoke probation. I'm going to follow the recommendation of probation. I'm going to revoke probation. I'm going to sentence him to 365 days in jail, credit 121